And Your Honor, in view of the application that lies before you, which, Your Honor, I will wish to characterize as legless and frivolous, Your Honor, there are material non-disclosures that have been made before you, which are aimed, Your Honor, at distracting you, so much so that, Your Honor, you do not protect the rights of the respondent who is before you. And, Your Honor, it's important I, with humility, direct the attention of the court to paragraph 4 of the supporting affidavit sworn by Sergeant Chesire. Your Honor, when you read paragraph 4, I will invite you to also reflect on paragraph 3. That while at paragraph 3, they are confident at the date in which the respondent was arrested, which is important. But subsequently, they withhold information to you on when the recoveries that they claim they have made were made. So much so, Your Honor, that if the recoveries were made almost a week ago, and they are satisfied that there is prima facie evidence that will warrant the charge of the respondent before you, then, Your Honor, the application before you does not make any legal sense, or rather there is no meaningful purpose for the application that has been filed before you. Your Honor, thank you. Your Honor, I'm saying that the reason why they have refused to disclose the date they made the recovery is so much so that you do not realize the amount of time they have had to reflect on the evidence that is in their custody, which time will have assisted them to arrive at a decision on whether to charge or not to charge the respondent. Your Honor, secondly, there is a mention of a case, particularly case number E092 of 2022, where it is claimed that the accused, or the respondent, entered into a plea bargain at Kahawa Law Courts. Your Honor, my submission is not to deny or to accept the very existence of that case. The essence of my submission, Your Honor, is to submit to court that counsel representing the applicant has, in a very creative manner, tried Your Honor, to misdirect their court to the bail and bond policy guidelines, especially when he came to creating a nexus between the bail and policy guidelines and that case, Your Honor. Your Honor, we must not confuse between the bail and bond policy guidelines and the sentencing policy guidelines of the year 2015. It is important when the court is to consider the appropriate sentence to a convict to reflect on the repeat, or rather the previous record of an offender. At the stage where the court considers whether bail or bond is going to be granted, it is immaterial, it is irrelevant that the respondent has a previous record But perhaps most importantly, Your Honor, what is important now, and what probably my senior will have alluded to you, is whether during that period of time when she was charged and upon her release on bail or bond, that she declined to respect the terms of the court. You have not been told that she was granted bail terms during that case and she refused to attend. We take it, Your Honor, and with humility. The reason for that material non-disclosure is because they know that previously, if at all, she's been granted bail terms and she has respected them. So much so that in this instance, she's deserving of being placed at appropriate bail and bond terms. Yes. Your Honor, I am very conscious of time. My senior alluded, Your Honor, while he was submitting, Mr. Omari, while he was submitting on the question of her being a flight risk, we made mention that we had even initially filed an anticipatory bail application in the form of a petition before the Kiambu High Court. This is number E103 of 2023. Sorry. I apologize, Your Honor. E103 of 2023, Your Honor. Nancy Kigunzu versus the Republic. Your Honor, noting too well that ultimately the court's duty is to rule as is decreed by the law and previous court precedences. I will urge, as I have previously urged the court, to reflect on the High Court decisions. The case, Your Honor, which I initially supplied, the case of Sudi Oscar Kipchumba versus the Republic of the year 2020, EKLR. Your Honor, equally, I will invite the court to reflect on the case of Michael Rotich versus Republic, the year 2016, EKLR. Your Honor, while you do that, especially when you reflect on the holding in the Oscar Sudi decision, reflect, Your Honor, on paragraph 24, the two principles that were set by the court. Ask yourself whether there are less restrictive measures that you can employ in this case, so that you balance what my senior is requesting to be granted to do and the right to liberty of the respondent. Yes. Lastly, Your Honor, I will wish that you reflect on the echo by Justice Professor Joel Ngugi, as he then was, while he echoed at paragraph 21, the decision by Justice Luka Kimaru. Your Honor, he, and I will say this very quickly, that it is wrong and unlawful for police officers to arrest people and present them to you only for them to ask for more time. If we are not careful, especially in view of this legless application, we might erode the very gains that the Constitution brought before us, Your Honor. Your Honor, I thank the court. The decision that my senior, Mr. Umbeta, was reflecting on, yes, which has been shared, is that Richard David Alden versus Republic, 2016, EKLR, Your Honor. I thank the court and I ask you with humility, allow her to go home. We can deal with other proceedings later. Thank you.
With my seniors who are representing the respondent, and I wish to respond to this affidavit that has been filed by the applicant dated the 22nd of August.
What's your angle?
My angle? Oh, yes. My angle in a nutshell is that the application that is before you is untenable and has not been brought in good faith. Your Honor, you are being told that the respondent fled. There is no proof. There is no proof to that effect. It is obvious that this is a court of law that deals with evidence. And the same has not been brought before you for your consideration. In paragraph 4, the applicant alleges that earlier search conducted on her rented house. They have not brought any proof that indeed that was her rented house. There is no annexure to that effect, nor anything that would persuade you to the effect that it was indeed her rented house. You're on paragraph 5, where they suspect that 13 million shillings was recovered, believed to be proceeds of crime. You know, the government of the day believes in the motto that this is a hustler nation. Are we then saying
political?
yes, by the applicant, and that the government of the day believes that this is a hustler nation? But does that preclude any hustler living in an area that is not a leafy suburb from having cash? Is there any legal provision under the laws of Kenya that prevent any person from keeping money in cash at their place of choice? This belief that it is a proceed of crime has not been substantiated by the applicant. It has only been haphazardly stated in a lousy attempt to persuade you. I will add briefly to what my senior, Mr. Wamboi, spoke as to paragraph 6. You know, there is no any court document which is well available to the applicant to show you that indeed this case that they have quoted is what they're alleging. They quote E092 of 2022 without citing any parties, without any document from court to actually verify the existence of this case to be linked to the respondent. In response to paragraph 8, Your Honor, the applicant swears that due to time factor, confirmatory laboratory tests have not yet been done, hence no report yet. And why I say this application has been brought in bad faith is because while the applicant was making reference to the mother file that I am also versed with, the 5 days proved not to be sufficient for them. It was only yesterday that they were seeking for 5 more days. Very well guided. All I will say is they did not consider the effect of what it is they're coming to ask before this court. In paragraph 9, the applicant alleges the likelihood that the respondent is to interfere with investigations. You know the case that Mr. Cliff Ombeta cited, R versus Dwight Sagaray, clearly states that speculation is inadmissible in a court of law. They have not adduced any evidence to the effect of this likelihood of interference.
You make an application for bail.
It is only stated.
She's released on bail.
The state has a tendency of making applications. Apologies for the speed. Is only stated, speculated, and not substantiated. You know, the state has a tendency of moving courts of law with miscellaneous criminal applications without trying to at least put the least effort to evidence their allegations. And as rightly put, this is the respondent is the sweetheart of this court today. Her rights ought to be zealously safeguarded. Seeing as there are no compelling reasons from this application, there is no reason why bail or bond with specific terms should not be accorded to the respondent, which ought to be reasonable. You know, you will note that the affidavit makes a prayer under paragraph 11, praying that the issue for bail and bond to be determined upon presentation of the respondent on a date to be determined by the court after the completion of investigations. As much as that is sworn in an affidavit, it has not been prayed for in the substantive notice of motion application. Can this court then grant orders where a party has not sought for the same? I believe not. And this court can only determine materials that have been placed before it. You know, the respondent has the advantage of presumption of innocence. And although it may come as a shock to the applicant, she is a mother of 2 minors under the age of 9 years. Yes, she has 2 minors under the age of 9 who still require the attention and the motherly love. And we do not believe that having the respondent in custody is going to interfere in any way with the completion of the investigation, owing to the fact of the matter that the respondent is not an investigator. Sorry, I can't hear you.
You said having her in custody, she's not going to interfere. Do you mean having her out on bond, she's not going to interfere?
Yes, that is what I mean. Having her out on bond, reasonable bond terms, she will not interfere. And in the event that happens, the applicant is well aware that they can move the court at any time to have the orders of the court for the bail and bond to be revised. Your Honor, as I rest my case, the respondent is not an investigator. She has nothing to do with the business of the applicant in the investigation of the crime they are alleging or incriminating her with. They are the ones who are the custodians of all the exhibits, and they can very well discharge their mandate.
Let them finish, we come tomorrow for play.
I thank the court for the time.
And given that much ground has been covered, I have also noted a problem with that application. That is, or rather should outrightly make it untenable in law. And very quickly, Your Honor, the question that this court should be asking is at what particular point do investigations cease? Such that, Your Honor, that the High Court in Betty Jemutai Kimeiwa versus Republic, Jemutai Kimeiwa, Kimeiwa versus Republic. That is a miscellaneous criminal application, 26 of 2018, and can be found in 2018 EKLR. Your Honor, the Honorable Judge, that is Honorable Murithi, went on record and posited that where an application is made for the continued detention of a person of interest, on grounds that are of a purely investigative, or rather investigative in nature, such an application, Your Honor, cannot stand. And for the reason is that those investigative steps are exercises that can be conducted where such a person of interest is out of custody. Your Honor, regardless of what the applicant states before this court ultimate thread that should bind such arguments is found in Article 49(1)(h), where the bottom line to be considered is whether that application has raised compelling reasons. And Your Honor, you will rather agree with me that the concept of compelling reasons is one that reverses the onus of proof. Therefore, Your Honor, I move on quickly then, therefore, to suggest how you can bring this solution as we move on to other things, Your Honor. Your Honor, I'll be making 3 cross applications and my apologies to counsel, given that we are just up with this application today, therefore it on my feet, is that the person of interest, given that now she's not an accused person, be admitted to bail forthwith. And Your Honor, it is our submission that the accused, or rather the person of interest before you, is willing to abide by those terms, no matter how strict they may be. Secondly, and as an alternative, is that the 5 days requested by the applicant be converted into free bond. Such that the accused, rather the person of interest, Your Honor, shall remain answerable to the DCI and shall be availing herself as and when need be and lastly, that the person of interest be, that is as an alternative to 1 and 2, be held at Muthaiga Police Station. That is notwithstanding the issue of proximity to Ngara, Your Honor. So, I mean, if at all that is the floating charge.
So please, I seek some understanding. And you wonder why I asked this. What is it about Muthaiga Police Station?
Your Honor,
I just seek to have an understanding.
Children.
yes, Your Honor. It's that basically we have intimated to this court that the person of interest is a mother. And it serves no purpose, really.
The other children arrested are in Muthaiga. The 2.
There's no really reason, Your Honor, that has been advanced as to why she should be held at the ICP police station. Secondly, Your Honor, she has 2 children who have also been arrested and are in custody in Muthaiga police station.
If all those are not, we come tomorrow for plea. Just leave it there.
Your Honor, I think those are just my compelling reasons. The reverse of honors was on me, so therefore those are my reasons.
We have nothing more.
We maintain that our application is properly before this court and is premised on the law. Then we reiterate section 123A, which should be read vis-a-vis Article 49. And we submit that we've met the threshold set out in section 123A. You know the character of accused of the respondent and the antecedents.
So in evidence, since these are required to go to be attendance, this will lead to
It will now guide.
And being a flight risk is a point of fact, it's not a point of law. So we left it the first time when he started, we let it go under the water and the bridge. You should not think and take it that we are acquiescing to the rebuttal on facts. The rebuttal should be on a point of law.
I even said it clearly that his colleague.
the prosecution represented by Mr. and Mr. Campbell. I also thank the attorney representing the respondents, Mr. Omari, Mr. Obeta, Mr. Nyaberi, Mr. Ngara Detained, Ms. Martina, and Mr. Kenji. Both sides have made submissions, referred to the law and cited authorities that the court needs to consider in order to deliver a ruling. The court thanks the advocates for their industry. Additionally, the court has one other matter to deal with that is being handled in camera. For this reason, and in order not to rush through the ruling, it will be delivered tomorrow morning at 9:30 a.m. The respondent will be detained at ICD police station. In view of the fact that the matter is now lying in court, the court reminds all parties of the side to this room. Tomorrow morning at 9:30. The reason we can't meet in the afternoon is because I have a lengthy hearing that starts at 12.
You know, we have a problem at on the question of 9. We are leaving at night today to Mombasa. There is still another Ezekiel matter in the High Court tomorrow. And could it be at 2? We can come late. After that, we can wait so that we fly back tomorrow.